Welcome back to the First Raitt Law podcast. And so we have another exciting episode for you. In this episode, we're actually going to talk about, do you have a case? And we're going to focus in on 4 of the most common cases that we get in our office. First, there's truck and auto accidents or collisions. Right. Second, we have slip and fall injuries. Third, dog bites. And then fourth, construction. Now, those aren't the only cases that we handle in our office, but those are the 4 most common. And so we're going to get into some of the nuts and bolts, what you need to do. Do you have a case? All of those things. And Bobby's going to lead us off by talking about those truck and auto crashes.
Yep. Truck, auto, motorcycle. We have a law in the state of Michigan where you can't bring a claim or quote unquote sue for any old injury. And the reason we have that is in 1973, we had a new law called the no-fault law. And I'm sure many of you out there have heard of the no-fault law in general and understand that we're a no-fault state. And what that simply means is even if you're at fault in an accident, you can make an insurance claim with your insurance company and get the same insurance benefits you would get even if you weren't at fault in that accident. The trade-off for that ability is that you can't pursue a claim or sue for any old injury anymore. It has to meet a certain threshold. That threshold is called serious impairment of body function. It's basically a bunch of crafty words that means you have to be pretty seriously injured. There has to be an objective component, meaning you have to be able to see the impairment or the injury. And then lastly, that it affects your ability to lead the lifestyle that you led before the trauma. And if you don't meet that threshold, you don't have a case that's going to get you compensation. Another issue in auto accident cases, obviously, is the other person has to be at fault. Doesn't mean you can't be partially at fault, but they have to be more than 50% at fault, because if you were more than 50% fault, and this gets kind of technical, you can't bring a non-economic claim, meaning for pain and suffering and your injuries. You can, however, if you are disabled from those injuries, bring a disability or a wage claim. And that gives you kind of a general understanding of auto, truck, motorcycles. But the truth of the matter is, it's certainly not, I get in an auto accident, I get in a motorcycle accident, and because I'm injured, I have a claim. There's certain factors and there's certain thresholds and there's certain issues with both fault and your level of injuries that you have to concern yourself with. Anything to add to that, Tom?
Yeah. So, this is probably one of the most confusing things for all of our new clients. Because, you have a friend who's from Ohio and she got into a car crash in Ohio and she stubbed her toe in the car crash and she was able to get $10,000. Why can't I have the similar case in Michigan? You're telling me my bruises aren't enough. Right. Or, especially like Chicago, too. Right. I have a friend in Illinois and he got $20,000 and all he had was a bruise on his arm from, an auto collision. And we're like, sorry. Right. We got to focus in on the law. Ohio has a much different injury compensation law than Michigan. Illinois has a much different injury compensation law than Michigan. And in fact, every other state in the United States has a different law than Michigan. We are unique. And so I would caution everybody, right, as you're listening to this, don't take your friends or your sister's example of what happened to them out in California and then try and say, well, I deserve the same thing out here. Our law is completely different. So,
and I want to add this because we're going to be talking about 4 different areas, as Tom mentioned. Both Tom and I started years ago at another law firm and primarily practice auto, truck, motorcycle accident cases. We have really learned the science, so to speak. We really know what we're doing. And even on first blush, if it appears that your injuries aren't that serious, we'll tell you what you need to do to make sure that you're not going to meet that threshold. Like monitor your condition, go to your doctor, document your initial injuries. If they continue, get the testing involved that'll help meet that objective component requirement. Contact us on a regular basis. Let us know how you're doing. And if we think we can help you, I say this all the time, there's cases we don't take where we help the people because we give them good advice. I also say that there's cases all the time that come to us and we are able to explain the law to the person so they understand what they need to do to meet the threshold. And then lastly, if we don't think we can help you, we're not going to waste your time. We're going to explain to you why. And a lot of times it's good news because it's usually you're just not heard enough, and that's a good thing, right? But the bottom line is, with our experience and what we've done for so many years, especially in auto, a lot of premises, dog bite construction too, we've learned it. We've learned the different areas. And the next one we're going to talk about is slip and falls, trip and falls. We call it premises liability law because it's happening on a premises, right? And with that, if you get injured due to a defect in the premises, on the premises, as part of the premises, then you potentially have a claim for those injuries. And what we look at when you contact us is, why did you fall? We start there. You got to know why you fell. I can't tell you how many times, and I know Tom knows this too. I'm not really
Oh
sure
boy.
why I fell. Well,
Right.
who do you want to sue? Why? So you have to know what caused you to fall. There has to be enough time, in other words, notice to the property owner, the person that's in charge of the property. That doesn't necessarily have to be the property owner in some management company situation. But the bottom line is we have to be fair. I talked to someone the other day. They fell at a roller skate rink. And I said, what did you fall on? Initially, they weren't sure. I explained the law to them. And then they said, I think it was some dirt. And I said, well, this is your problem. Let's say you're skater B. Skater A is in front of you. They drop that dirt. 2 seconds later, you fall in that dirt. How are we going to hold the skating rink liable or at fault or responsible for that defective condition? So there has to be a reasonable chance for the property owner to address the defect. If we have all of that, if we know what you fell on, if it's a defective condition, because some things they're not defective. They just happen to be on the premises, and quite frankly, you were at fault for falling on the thing because it's something that's there, it's in full view, it's not anything defective. So we analyze the whole thing and we instruct you all along the way. And then if we get to the point where they should have done something about it, a really good example that people in Michigan especially know of, if you slip and fall on ice, there's a whole area of premises liability law about slip and fall on ice with very particular requirements that we're well versed in. But the bottom line is we always look to show that the owner of the premises had reasonable time to salt, sand, address that ice, because if they didn't, it's very hard to hold them responsible.
Yeah, and one of the things that I heard that you said that's really important to highlight is the kind of the accountability of the person who's walking, right? The person who ends up being injured, and whether or not they're heading into an area that is open and obvious, right? A danger that is open and obvious. So we'll get these calls where someone's like, "Yeah, there was this huge hole in the middle of the parking lot, right? It was 5 feet wide. And when I stepped in it, I broke my ankle." And we're like, oh, all right. Well, that's getting into that negligence issue, right? And a contributory, comparative, all of these words that attorneys use. But basically, right, you can't walk into a hole that's in broad daylight, right? That's 5 feet wide and break your ankle and likely have a case in that scenario. Even though it's big, right? Because they're like, it's so big, right? But yeah, you should have walked around it. So always think about those considerations too, right? And those are the things that we'll highlight to you, where, you might call one attorney and they're like, sounds great, we're going to do our best for you. They sign you up, and then your case gets dismissed, and then you're angry, right? In those facts, you'd call us up and we'd say, you know what? You probably don't have a case here, and then save you the hassle of going through all the heartache of going through these cases only to have it dismissed. So in all these situations, right, do I have a case? That turns also on your conduct and your actions, and we analyze all of that when we meet with you. So tell us about dog bites and dog knockdown, right? Because those are different, but people don't think of those as different.
I even have another one to add to that, and I have a personal story with it. But bottom line is, if a dog does something wrong and you are injured, you have a potential claim. One of the biggest offenses is what's called provocation. You can't go up to a dog and go, and then when it bites you, successfully have a claim. that just is part of our law. Again, it's a comparative component, just like that big pit that you fell in, or being more than 50% at fault in an auto truck accident. It's the same thing. You can't provoke the dog. But, much of the time when people talk about issues with dogs and injuries, they're thinking bite. I have a personal experience, and we have a recent case that we signed that shows that it doesn't just have to be a bite. My personal experience, unfortunately, I lived in a home for many years, and I had a next door neighbor who was a nice enough guy, but he was scared of dogs. And we had the cutest, the nicest dog, and he would always say, "Your dog's really aggressive, man." And I'm like, "No, he's not, but I get it." So we would try to let him out to the back, not the side. One day I open my garage, the dog runs out. I don't even think about it. I'm doing something with my car, and I hear what I believe is a little girl scream. And so I'm like, what the hell? So I go to the other side of some large bushes that we have on our property, and I see my next door neighbor in a short sleeve dress shirt on the ground on a little hill. So his head's higher than his legs. My dog is at his feet barking at him. And he is screaming like a little girl. And I said, "What's wrong?" He said, "Your dog attacked me." And at that moment, I had my phone. I turned on my audio portion of my phone and I said, "Albert, I don't think he bit you. I don't see anything on your pants." "Well, he lunged at me." I said, "How did you get to the ground?" "He put me here." I said, "Okay, are you okay?" He said, "I hit my head." I said, "On the grass?" And I was trying not to laugh, but at the same time, I was realizing this guy's going to sue me. So I said, "Let me get my dog." So I take my dog, I put him inside. I turn to my wife and she's like, "What's going on?" And I said, "Go, Albert's on the ground in the back. He claims that our dog bit him." She said, "Oh." So she goes out there, and she was out there for like a half hour getting his glasses, comforting him, doing all this. I go out there, "So sorry, so sorry." And I said, "He's going to sue us." She said, "No, he's not." I waited a couple hours. I called him to see how he was doing. And he was at the emergency room. And I said, "You're at the emergency room? Who drove you?" "My ex-wife came and got me because I don't have anyone else to drive me. My head's killing me." I said, "Okay, Albert, please tell us how you're doing. Keep in touch." I knew we were in trouble when that happened, but I really knew we were in trouble when a day later and I hadn't heard from him. I called him. It went right to voicemail. I left him a message and he never called me back. 3 months later, I heard from some young attorney. "Hey, Robbie, I had Albert in my office today." I said, "Yeah." He said, "You know how this goes." I said, "Tell me, how does it go?" He says, "You just pay me a little something. Tell your insurance." I said, "We didn't do anything wrong." Well, that wasn't true, because another part of dog injury cases where you can have liability is for trespassing. My dog was on his property. And although he could never prove that my dog bit him, because he didn't, he was able to get by the legal part of that, the liability part about that, showing that he was on the property. Now, we resolved the case for virtually nothing. It was a bad experience. It obviously put a bad taste in my mouth. But I learned as an attorney that I never knew. Your dog on someone else's property, if they get injured and it has anything to do with your dog being on their property, which in this case, arguably he fell because my dog was barking at him, there's liability. And then, Tom, tell about the most recent case that we just signed. It gives a little different spin on dog bites, even though it wasn't a bite.
So we recently signed a case where a mother of two, wife, she's walking their family dog in the neighborhood. And as she's walking down one of the streets, because she normally goes on like a 2.5 mile walk with her dog every day, and on the walk, she's going down this one road adjacent to hers, and then all of a sudden, a larger dog comes out. Uh, she thinks it came out of a car, but it doesn't really matter where it came out of a car, whether it came out of the front door. It runs across the street and starts attacking her dog. Now, there were no bites involved, but during this scuffle of her trying to separate the dog away from this dog, her dog from there, that their dog like bumps into her leg. I mean, very hard. Now I know, right? It normally doesn't sound, oh, the dog bumped into your leg, but what it actually did was it caused a fracture. And the fracture was to her tibia just below the knee. So it's a pretty bad fracture. She eventually, right, she goes to the doctor. They have to get it all worked up. She's still in treatment for all of this. It's all pretty fresh. But this type of case, right, where a dog is leaving its property, coming out across the street to then attack your dog, even though there's no bites, clearly there's negligence on there, right there. So there's issues with regards to whether or not the dog should have been leashed, whether or not the dog should have been controlled, all of these things. And these are things that we're starting to look into. That one's a pretty interesting case. So we have another dog, actually, this one's an actual dog bite case. So a young girl was in her front yard. Actually, her whole family was in the front yard. Dad was trimming the hedges. Mom was doing some weeding, and the young girl and her sister were playing in their grass, right? And just, they're doing their thing, and there's a dog being walked on their sidewalk. And as the dog gets closer to their house and their front yard, you can see kind of the dog kind of look up. There's another dog that comes in. They sniff each other. Everything seems to be fine. And then all of a sudden, you'll see the dog change direction and just lunge after our client, this young little girl. In fact, she's 8, right? She's 8 years old, and it's a bigger dog. It in fact pulls off the leash from its owner and bites her on the arm and grabs her. And it was probably like a good 12 or 15 feet into their front yard. And so she has these puncture wounds. She has 3 puncture wounds in her arm. And she goes and gets treated. There was an infection. So obviously that's awful. It creates more pain and obviously more suffering with regards to the puncture wounds. But internally, she's okay, right? Internally from the puncture wounds. However, for an 8-year-old to get attacked by a pit bull while playing in her front yard was very damaging for her anxiety, right? For her psychiatric claims. I mean, we always hate using that psychiatric word because it sounds, right? It sounds so medical. But it's real, right? So all of these things with regards to anxiety, all of these things with regards to being afraid of now their own family dog, of the neighbor's dog, these are all real, very real feelings for this young little 8-year-old. And so while the physical injury wasn't completely disabling, won't be permanent except for the 3, puncture wounds that are going to be there in her skin, the psychological harms to this young girl are significant. And she's getting treatment. She's getting the therapies that she needs to get beyond this, or at least try and get over it as much as possible. So it's not just the physical components of having a broken leg, right? It's not just the physical components of being bitten or being knocked down or hitting your head, but it's also all those other issues that we end up retaining and a lot of times hurt us worse than the physical harms that we suffered at the beginning.
Yeah, I was negotiating on that case. We were not able to resolve it. Probably filing suit, right, Tom? We're filing suit on that one.
Yeah, we are. We're filing suit on that one because the adjuster's unreasonable.
And what the adjuster is doing is she's not giving the kind of credit to the psychological problems this little girl is having that it deserves. I mean, that is much more valuable, we'll call it, than the puncture on her arm because it's about 2 years after the dog bite and she's still picking at her eyelashes. She's still in regular ongoing therapy as a little girl. And there's no sign that this is going to completely go away. So to Tom and I, fortunately our client's mother, who we've been talking to, is on the same exact page because we would never recommend settling for something like the insurance company was talking about because it gave value perhaps to the puncture and that was it in our mind. So, we're going to get a bigger bang for our buck if we file suit on that one. It's a perfect example of how we tried. We just couldn't settle for something that was reasonable.
Well, and that highlights what we talked about in some earlier podcasts too, and some of the earlier episodes where, if an attorney doesn't take the time to meet with the family, right, to meet with the injured person's family, not just the injured person, but get to know their family members. Ask, mom, how this is affecting the daughter. You just don't ask the daughter. And I get it, 8 years old, but I'm talking even adults, right? So you don't just ask the injured person, how are you doing? How is this affecting you? You ask their spouse, how is this affecting your spouse? You ask their children, you know, Johnny, Johnny, how is this affecting your father? How has it affected your relationship? So understanding all of those components is what we do, right? It's what separates us. And certainly without that, right? Because if you look at it on the surface, a 3 puncture in the arm case isn't much of a case by itself. But holy smokes, if someone did that to my daughter and caused her that kind of psychological harm, I'd be out for blood. And we're in it with the family too. We're in it for them.
Absolutely. All right. The last one that we deal with a lot are construction site injuries. And I'll start out with kind of a story that explains one of the biggest issues with construction site injuries and whether there's a quote unquote case. And that is a case I had years ago that actually another law firm turned down. And our intake person at the time had it and reviewed it and was right about to send it back and say, we don't think there's liability here. And he knew that a referral source of mine sent it to that firm. So he said, you might want to look at this. And I did look at it. And I talked to one of the senior attorneys there that does a lot of that type of stuff at the time. This was years ago now. And we both agreed that there was an angle here. And what we were looking at liability wise was this. When you're on a construction site, there's a lot of different companies likely on that construction site. One is obviously yours, your employer, you work for them. Another is the general contractor, the one that kind of oversees the entire project. And then there's subcontractors, very likely like your company, that does a specific task or two on the construction site during the process. We have no problem if another subcontractor is at fault for your injuries. Say they left something over a hole and you walked over there and fell through the hole. That's a general example. We can go right after the subcontractor. To bring the general contractor in, there's very specific laws about what needs to take place. If we have those facts, we can bring in the general contractor as well. And we go through all of the different requirements and make sure that we can pursue that. The problem you have a lot of times, and we were facing that potential problem in this case, is that your own company or their employees, your co-employees, are at fault for your own injuries. And under our law, that is exclusively an area of workers' compensation law, not negligence law. And Tom and I, as negligence attorneys, personal injury attorneys, where our hands are tied. We can't bring a negligence case. There are exceptions, but they're not even worth going into now. Although if they're there, we know them. And if they didn't carry certain insurance, we can go after them for negligence. But the bottom line is most of the time we cannot go after the employer of our client for their negligence. They have to exclusively go through comp. In this particular case we had, our client was working, him and his family were from Las Vegas. He was working for a company here in Michigan, and he was on a job site, and they were doing a lot in buildings. And as one of the jobs he had on this particular day, he was swapping out gas lines. And we knew very little about the situation, but long story short, there was an explosion. He suffered injuries through 80% of his body, eventually died from those injuries. What my intake guy thought in reviewing everything, what this other firm, very well-known, prominent, large firm in the area thought was this was his employer because his employer sent this young man, he was 26, 27, something like that at the time, sent this young man to this building to do this. They shouldn't have done it without the proper protections. Therefore, it's exclusively workers' comp. What we thought is we might be able to bring in the general contractor. And why? Because they had control of this building. They presumably would have had to sign off on this company being in the building, this guy being in the building, doing the work. So we were going after the general contractor because we felt if they knew about it and allowed it, all the requirements of bringing a general contractor into a case were met. Well, a lot of litigation, a lot of relationships, I'll tell you. There was some defense attorneys that could have been in the case that ended up not being in the case. There was some defense attorneys that I know very well, that I respect very well. We have mutual respect. We were able to take the case and we were able to avoid getting thrown out of the case because you can bring what's called a motion telling the judge, look, there's just not the liability or the negligence or the law to prove the case. We were able to skirt that, get around that. We got it into what's called a mediation or facilitation, and we were able to resolve the case for a little over $1 million for this family. And had my intake guy, had the other firm just been the last call, the family might have just gone away. And what's interesting about it to me personally is I had never met the family because they were in Las Vegas. I did a lot of Zoom, I did a lot of that, and it was during COVID. It was in like the spring of 2020, and we were able to get it into a facilitation, and that facilitator had a recommendation, and I had to convince my family to take this recommendation, and if both sides took it, it settled. So I talked to the defense attorney. She was going to talk to her people. I got on a plane. I was one of 3 people, full mask, the whole thing, on this Delta flight to Las Vegas. I rented a car. I drove across the strip. I went to this very cool, unique, they were a Mexican family. There must have been 20 people in that house. It smelled great. They were cooking. I sat them all down and I did my best closing argument as to why this wasn't about their young son, young brother, young father. This was about what was the most we could get. Because if we valued this kid's life, we'd be talking 20, $30 million. But that wasn't the issue here. The issue was, are we going to be able to convince a jury given this law? And we stand to get 0. And it was very tough to do. But at the end of the day, and really to say end of the day, I had to get back on a flight 3 hours after I got there. And I just made it because I did everything possible to make them understand I knew what the hell I was talking about. I wanted to do right by them, and I wanted to make sure they didn't get hurt. And they finally agreed to it. They signed off on the dotted line. And long story short, the other side agreed to it too. And we wound up settling that case. But, you know, the liability and the one issue that's always prevalent in these construction site accident cases are, was your employer the one that caused your injury or a co-employee caused your injury? Because it's an exclusive remedy and you can't bring a negligence claim.
Yeah, you know, 2 things kind of really stood out for me as you were talking about it. One was you mentioned that another firm had rejected it, and our prior firm almost rejected it too. And so, how many cases has that happened, right? How many times have we taken on cases where someone else is like, oh, there's no case, right? Because they're just looking at the surface, right? They're just looking at maybe the initial police report that's provided, and they didn't actually dig deeper to look, right?
Or
Because
even when they
in your
undervalue it, like the case you were just
yeah,
referred that you just said.
oh yeah, those guys, yeah,
But you know what I'm saying?
I'm like, oh, it's so mad when like people try to undervalue cases because it's the easier thing to do or things like that. But on this like firm rejected, it reminded me of a case from my last firm, right? Our last firm, and in that case, there was a case that was rejected by all the other attorneys, and in fact, on first glance, I'm like, oh, I don't know about that because the police report had it was an auto collision, and the police report had our client 100% at fault. But there were also witnesses on that police report that no one else bothered to call, right? And so I'm like, gosh, this person is so badly injured. It's worth a couple phone calls, isn't it? Absolutely. Make a couple phone calls. Their eyewitness recount of what happened did not match the police report at all. And so that was interesting. So now all of a sudden I'm like, I'll take that case, right? All it took was one phone call to one witness that was listed on the police report. Start investigating. And that case turned out to be a full policy limits settlement, right? And the policy limits was $1.25 million. That was a case that was rejected by another law firm, and every other attorney, this was after you left the firm.
How about the one we just signed? We just signed a case, and it's not like it was going to be fully rejected, but we have a path to a second potential wrongdoer because Tom looked at it, and it was a case where 2 people were on a motorcycle. We had the passenger, and the only one the police officer seemed to talk to from the police report was the truck driver coming the other way, and it said that the motorcycle crossed over center. Both the driver of the motorcycle and the passenger of the motorcycle lost their foot, both amputated, like as if it was a side view mirror and they just took off their foot. In fact, word had it that the toes of the driver were embedded in the wheel well of the truck. And Tom's first instinct was to say, hey, look, these motorcyclists were gravely injured. You think they talked to the police? You think they told their side of the story? So don't be so sure that it's just the driver of the motorcycle. I bet you anything they have a different story. And that's exactly what's been happening. We signed it recently. We've talked to various people. We're getting in touch with witnesses, insurance adjusters that are doing a good job. And we're finding out more and more that it looks like there's fault on both sides. And that brings in another policy for our client. And that's very helpful. So, we do the work. We dig and we look at what things are and we look at what we know based on our experience. And, again, we can get you what we need to get you if it's there. Bottom line is this. We handle pretty much every kind of personal injury case. We don't handle medical malpractice cases. We happen to know a string of 3 or 4 outstanding medical malpractice attorneys. So I tell everyone, call me with anything. I spent much of my career, as Tom has, networking with all different types of attorneys. I take pride in being able to help people that call me, whether you're going to stay with our firm or go to another firm. If you have a medical malpractice question, give me a call. I'll get you to the right person. But on these 4 areas, auto, truck, and falls and dog bites and construction site accident, I don't toot our horn, so to speak, a lot, but the truth is you're not going to get anyone better. I tell people all the time, you may be able to get people as good, maybe. You're not going to get anyone better than Tom and I are in these cases. We're going to handle it from start to finish correctly. Give us a call at 866-RAITT, R-A-I-T-T Law, L-A-W, or go to our website, www.first, Raitt Law, Law.com. We'll be happy to answer your questions and try to help you.